Hello everyone, welcome to yet another session of the Daily News Analysis by SRIRAM'S IAS, where we take up the important articles from the Hindu newspaper and break them down for understanding from the UPSC examination point of view. So let's start our today's discussion by taking the important articles which feature in the New Delhi edition of the Hindu newspaper. So the first article that we've taken up from the newspaper are a set of two articles which first appear in yesterday's newspaper, that is 21st of November, that reads a first look at the new data protection bill, and the second part of this article appears in the edition of 22nd November, which reads how different is the new data protection bill. So these two set of articles actually are appearing in the newspaper because a new draft of the data protection bill has been brought out by the central government, and it is out for public consultation. So whenever we trace the journey of a bill becoming a law, we know that first a bill is brought out by the respective ministry, whoever is in charge of handling the subject. That particular ministry brings out the bill, then that bill is kept open for public consultation so that all the general public, experts, all the people who are interested in the bill can take a look at the bill, can give their inputs and suggestions, and then if the ministry wants, they can alter the bill. Then this bill goes to the parliament for the passing of the bill, and when both houses of the parliament pass the bill, then this bill becomes the act of a parliament and the law of the land. So currently the central ministry has taken out a fresh draft of the new data protection bill, or the data protection bill 2022. So this is a significant development because, as most of us would be knowing, in the month of August, the previous Data Protection Act, which had its journey started way back in 2018, it was withdrawn suddenly, and therefore its withdrawal caused a major sense of urgency in terms of having a data protection law, and now a new set of data protection bill has come into the foray. So therefore, from the examination perspective, we'll analyze what this new data protection bill is all about, how different is it from the old one, what new changes are being proposed in this, what are some of the merits of the new bill, and what are some of the challenges, the challenging areas that remain, which we should be giving more focus to and rectifying. So let's understand the whole debate about the data protection law in India and the new draft data protection bill. Before we move on to discussing the draft, we'll understand the journey of the data protection law in India. From where exactly did it all start? So the central government set a committee under the chairmanship of B.N. Srikrishna. He was the ex-justice of the Supreme Court. So just under Justice B.N. Srikrishna, a committee was set up, right? And that committee gave out a blueprint for setting up of a data protection law. And in July 2018, after a year of consultations and deliberations, the PDP, or the Personal Data Protection Bill, drafted by an expert committee headed by Justice B.N. Srikrishna, is presented to the Ministry of Information and Technology. So as I said, the respective ministry of the subject of law takes care. So in this case is the Ministry of Information Technology, Electronics and Information Technology. And then this ministry begins the drafting of the next iteration. Then in the month of December 2019, a year later, the Personal Data Protection Bill 2019, prepared by the ministry, is referred to a joint parliamentary committee for a review. The bill was ready, it went to the parliament, and whenever a bill goes into the parliament, for the scrutinization of the bill, it is referred to a parliamentary committee. So in this case, it was referred to a joint parliamentary committee, and in December 2021, the committee also took its time. So after multiple extensions and a leadership change, the JPC chairperson tabled the report of the Joint Parliamentary Committee on this bill, as well as the Draft Data Protection Bill 2021 in the Parliament. And this particular parliamentary report flagged certain concerns with respect to the initial draft, and therefore on August 3 this year, the Ministry of Information, Electronics and Information Technology withdrew the bill of the 2021 bill, stating that a more comprehensive legal framework will be presented soon. And therefore, after few months, we are here with the new draft. Now let's talk about the new Data Protection Bill 2022 and what is it all about. So talking about this bill, the explanatory note of this draft says that this bill is based on 7 principles. Now when we talk about the data protection law in India, we had discussed earlier that data is the new currency in the world right now, and that is why it is the most precious thing, one can say, in a lot of aspects. Therefore, protecting data, having the best laws suited to data governance is the most important need of the hour. Therefore, protecting this data is the most important thing. Therefore, any law that would be made on the data protection or the aspects of data governance has to take care of all the stakeholders in the foray, which means that those persons, the consumers whose data is taken by the government, taken by the companies, their interest should also be safeguarded. Those companies which are taking part in the e-commerce sector or the business economy, they also need to be equally safeguarded and encouraged so that the collection of data is equally beneficial for them, and the safeguards that they need to keep in mind, that is also very practicable for them. Then the government's role in this is also very necessary, where the government should have enough powers to govern on data, and it should have adequate accountability in the aspects of data governance as well. So all of these things are very important, and therefore all the stakeholders need to be satisfied when it comes to having a robust data protection law. So having kept this in mind and the importance of having a robust data protection law, let's understand what these 7 principles are in this new draft. The first is lawful use, which means that any data that would be collected by any person would be used lawfully. The first is that usage of the personal data by organizations must be done in a manner that is lawful, fair to the individuals concerned, and transparent to the individual. So the first principle is lawful use. Any data that is collected should be used lawfully by the entity, collecting entity. Second is purposeful dissemination. This second principle states that personal data must only be used for the purposes for which it was collected. This means that data should not be used for the purpose that it did not state. The company that is collecting the data should state the purpose for which it is collecting, and then only use the data for that purpose for which it collected the data. This is known as purposeful dissemination. Then data minimization is the third principle, where bare minimum and only necessary data should be collected to fulfill a purpose. Then data accuracy, where at the point of collection there should not be any duplication. Then the duration of storage, how long will the data collected by the companies and entities will be stored for. So it talks about how personal data that is collected cannot be stored perpetually by default, and storage should be limited to a fixed duration. The next principle is authorized collection and processing. This means that there should be reasonable safeguards to ensure that there is no authorized collection or processing of the personal data. And last principle is of the accountability of the users, which means that the person who decides the purpose and means of the processing of personal data should be accountable for such processing. These are the 7 principles which the draft of the data protection bill mentions. So these are the overarching principles. Now let's understand, using these principles, what are the key features of the bill. What does this bill talk about in its various clauses? So the first few clauses of any bill talk about defining the important entities who are involved in the data governance. So it defines data principal and data fiduciary. Now what does this mean? Data principal in simple language is the person who's giving the data. That is why the word principal. So any person, let's say if I am using my phone and it is my data which is being transferred to the person who is collecting my data, so I am in this case the data principal. And who is the data fiduciary? That entity. So for example, if I'm using any social media site, that social media site collecting my data is the data fiduciary. And what we mean by fiduciary is in the context of this person is receiving a particular object and he is responsible to handle that object. So this means that the ownership of that data belongs to the data principal, and the data fiduciary is the one to possess that data and has to responsibly handle it. That is why the word data fiduciary. This can be an individual, company, firm, state, anyone can be a data fiduciary, right? And data principal is to denote the individual whose data is being collected. Then the law also makes a recognition that in the case of children defined as well as all users under the age of 18, their parents or lawful guardians will be the considered data principals. So what would be the case of children who are under the age of 18? In that case, the permission to collect data or not would be given by their parents or guardians, and therefore their parents and guardians would be named as the data principals. So this is the definition clause. Then it also defines what is personal data and what do we mean by processing of this personal data. So under the law, personal data is any data by which or in relation to which an individual can be identified, which means that any information using which an individual can be identified, that data would be known as personal data. And what would be mean by this processing? So processing of this data means the entire cycle of operations that can be carried out in respect of personal data would mean processing of this personal data. So right from collection to storage of the data would come under the processing of the data under the bill. These are some of the definitions under the bill. Then we have a feature on individuals' informed consent. This would mean that any entity which is wanting to collect the data has to take the consent of the data principal. So it makes clear that individual needs to give consent before their data is processed. Every individual should know what items of personal data as data fiduciary wants to collect and the purpose of such collection and further processing. And not just this, the individual will also have the right to withdraw consent from a data fiduciary, and it gives consumers the right to file a complaint against a data fiduciary with the Data Protection Board in case they do not get a satisfactory response from the company. Now this Data Protection Board is the governing entity which has been established under the new draft, which this was earlier known as the Data Protection Authority in the earlier version of the bill, the Data Protection Bill 2019, and this has been renamed as the Data Protection Board. How exactly is the Data Protection Authority in the previous version different from the Data Protection Board? We'll come to that in a bit. But according to this feature, any complaint that the user might have with respect to either the consent of the data or the processing can be lodged with the Data Protection Board. Then the language of information has to be as specified in the 8th schedule of the Indian Constitution. This would make the information which accessible to all citizens. Then we have the significant data fiduciaries. Now there are some companies which are larger than the other companies and therefore hold more sway when it comes to decision making and the choices of people. And these companies are named as significant data fiduciaries under the Act. So the bill talks about these significant data fiduciaries who deal with a high volume of personal data. Central government will define who is designated under this category based on a number of factors ranging from the volume of personal data processed to the risk of harm to the potential impact on the sovereignty and integrity of India. So using these factors, how much is the volume of data they are collecting, what impact that data processing and collection can have, can it impact the safety of the country, taking into account all these factors, certain high volume data processing companies would be designated as significant data fiduciaries. Obviously, when they would be named under such a special category, the obligations and safeguards against them would be more severe or more complicated. Then the next is Data Protection Officer and Data Auditor. Now these are the two designations which have been instituted under the new draft, where these entities or the data fiduciaries who will be collecting the data will have to appoint a data protection officer who will represent them, and he will be the point of contact for grievance redressal, and they will also have to appoint an independent data auditor who shall evaluate the compliance with the Act. So these are the two designations that have been enumerated under the new bill. Then is the right to erase data or right to nominate. Now, this is a significant feature in the bill where the data principals, where when they've given the data, it is within their right, will have the right to demand the erasure and correction of data collected by the data fiduciary. This is something known as the right to be forgotten. This is quite a talked about right, and this particular data protection bill, we can say that in somewhere takes up the issue of right to be forgotten and gives the data principals the right to demand the erasure and correction of the data. They will also have the right to nominate an individual who will exercise these rights in the event of death or incapacity of the data principal. So it also gives them the right to shift the responsibility in case of any death or incapacity to other people. Then there is the feature of cross-border data transfer. This pertains to the concept of data localization, which we took up a few days ago. Data localization was the storage of data in the domestic country and restrictions on transferring that data from the domestic country servers to the foreign country servers. So what does the new drafts talk about data localization? This new bill is allowing for cross-border storage and transfer of data to certain notified countries and territories. What does this line mean? This line means that we can say that there has been a dilution of the data localization laws and the amount of strictness that the Indian government wanted to maintain with respect to data localization. Earlier the stand was that we would be very strict with respect to the data being transferred out of the country, and without our permission no data should go, and there should be a mandatory domestic server which should be maintained in India. But according to the new bill, it is allowing for cross-border storage. Entities can take data out of India, but these would be within certain notified countries and territories. So only limited countries, and those countries which the government is notifying, only to those countries the cross-border storage and transfer would be available. However, an assessment of the relevant factors by the central government would precede such a notification. So all the assessment would be done by the central government and then such thing would be allowed. So this is a unique feature or a new feature which is seen in the new bill. Then the financial penalties. Now the financial penalties under the Data Protection Bill 2022 are a point of highlight because the penalties have been increased for the crimes that the data fiduciaries or other entities can commit. So the draft proposes to impose significant penalties on businesses that undergo data breaches or fail to notify users when breaches happen. Then the entities that fail to take reasonable security safeguards to prevent that personal data breaches will be fined as high as rupees 250 crore. And as per the draft, the Data Protection Board, which is the new regulatory body set up by the government, can impose a penalty of up to 500 crore if non-compliance by a person is found to be significant. Why is this high amount of penalty being instituted under the new law? It is being done because in the past 1 or 2 years, we have had some instances of cyber attacks, cyber hacking, where important structures and institutions of the country were seen to be compromised with the effect of these cyber attacks, and therefore a lot of data leaks have also been reported. So in order to safeguard all this and to make these entities, business companies more responsible towards having a safeguard mechanism, it is being the high amount of penalty has been kept due to this, so that they are more forced to act and maintain a robust safety system. This is why the high amount of penalties have been included under the new bill. Right? So what distinguishes this bill from the earlier version? First is the gender neutrality, which means that the language of the drafting of the bill is being used gender neutral, and is for the first time in the country's legislative history, the terms her and she have been used irrespective of an individual's gender. So in terms of drafting a law, it's a significant development that has happened. Then second is it imbibes best global practices. So the framers of the bill have said that they have consulted all the data protection laws, the major countries' laws with respect to data protection, and they've taken the best concept. So to prepare it, best global practices were considered, including review of data protection legislations of Australia, EU. The European Union had the first data protection legislation, which is known as the GDPR, or the General Data Protection Regulations, that of Singapore, and a prospective one of the USA as well. Then the next feature is of comprehensiveness, where more number of features are seen in the new version of bill, and special emphasis for child protection has also been added under the new bill. So these are the new features which are different from the previous version. So therefore, what can be called as the merit of the bill? Whatever features we saw, the comprehensiveness of the bill and the widening scope of the data is a merit of the bill. So narrowing the scope of the data protection regime to personal data protection is a welcome move, as it resonates with the concerns of various stakeholders. Then it would also, having a law would give a clearer picture to the business entities, and therefore it would be able to harness economic potential. Now that non-personal data could be used to unlock. So this bill is only for collection of personal data. The non-personal data can be used to unlock social and economic value to benefit citizens, businesses and communities in India which appropriate safeguards in place. So, and the concept of data localization dilution would ensure free flow of data. So that can be called as an advantage, where the companies are also encouraged to use data. So therefore the free flow of data will help startup access cost-effective technology and storage solutions. Then allowing data transfers. Now this is a merit of the bill, where it ensures that India is not isolated from the global value chain, helping businesses stay resilient in production and supply chain management and fostering overseas collaboration. So the feature of transferring of data is also a merit of the bill. But what can be called some of the criticisms or challenging areas of the bill? There are also plenty of challenging areas which various experts have pointed out. One is the wordplay, which means that there are a lot of words used in the bill which are very vague and give overarching or arbitrary power to the state. So use of open-ended language such as necessary or as may be prescribed. These words give the ultimate power rests with the central government or the central authority, and that is why this can be a warning sign for again arbitrariness to come, and therefore when there is no accuracy or specificity, it can amount to misuse of the power by the government. This is first criticism. Then the government monopoly as a red flag has been pointed out by a lot of experts, where it is seen that the amount of protection that is granted to data principals and fiduciaries is still okay, but it did not seem to work towards protecting people but ensure that government retains all power without any checks or balances. So this is seen from the fact that the new data protection board which is instituted, the appointment of the chairman is going to be done by the union government. The earlier data protection authority was a statutory body, whereas this data protection board is now going to be a central government set up board. So the adjudicating authority under the act, the powers of the authority have been diluted. The appointment is going to be made by the union government, which would mean that the accountability of this particular chairman and the members of the data protection board can be compromised, since their appointment is directly done by the union government. Then all the safeguards that are there for the business entities, the central government says or the law says that it might not apply to the central government agencies as and when it might want. So this is known as the exemption provisions. This is another criticism, where the government has been given the power to exempt not only government agencies but any entity that is collecting user data. So this means that it is the government which can decide which entity, either government or otherwise, it can exempt that entity from any rule from this bill. So from having to comply with the provisions of this bill when it is signed into the law. So these exemption provisions, which signify that a lot of power has been kept by the government with itself, is given as a criticism for the bill. Then there is no protection against data breach. The executive in India has a track record of exploiting to expand its powers, and there is no right for compensation to individuals in case of a data breach by the government, and therefore they have no right to data portability. So this is cited as some of the criticisms of the bill, and this was a discussion with respect to what this new bill is all about, what are its key features, and what are some of the challenges that exist. So going forward, what needs to be seen is its aspect of data governance is a huge aspect, and therefore the good step is that a bill has finally come, which means that the vacuum which was there of not having a data protection law, at least to fill that, the first important step has been taken, but many aspects still remain where discussions are required, and the proper management of the powers and rights and duties of all the stakeholders need to be managed, and therefore much work needs to be still done in this aspect. So we finished this article and we'll move on to the next article for the day. The next article which appears in the newspaper reads, Union Health Ministry launches India's first suicide prevention policy. So the Ministry of Health and Family Welfare has introduced a new suicide prevention policy. This is being done to check the increasing amount of suicides in India, where in India more than 1 lakh lives are lost every year to suicide, and it is the top killer in the 15 to 29 years category. So the incidence of suicides is increasing, and in the past 3 years the suicide rate has increased from 10.2 to 11.3% per 1 lakh population. And the most common reasons for suicide include family problems, which means personal problems, illness, which account for 34% and 18% of all suicide related deaths. Therefore, the Ministry of Family and Healthcare has brought out a comprehensive policy. This is a first of its kind in the country, with time-bound action plans and multi-sectoral collaborations to achieve reduction in the suicide mortality by 10% by 2030. This is the mission statement of the policy. This strategy broadly seeks to establish effective surveillance mechanisms for suicide within the next 3 years. So this policy pertains that there should be surveillance mechanism, which would mean that surveillance should be there on which are the people more vulnerable to suicide, and therefore they can be identified and helped within time. Then to establish psychiatric outpatient departments that will provide suicide prevention services through the district mental health program in all districts within the next 5 years. It seeks to integrate a mental well-being curriculum in education institutions within the next 8 years, and envisages developing guidelines for responsible media reporting of suicides and restricting access to the means of suicide. We all saw the kind of reporting that was done on the death of certain famous stars and the suicide pertaining to these stars, and therefore responsible media reporting should be done on these suicides is also something that is envisaged in the policy. And the stress is on developing community resilience and societal support for suicidal prevention. And this strategy is in line with WHO's Southeast Asia region strategy for suicide prevention, with proper attention given to the Indian ethos and context as well. So this is the important aspect with respect to the suicide prevention policy. This has just been launched. So this is the vision statement right now. How it materializes into the future and how it performs remains to be seen in the coming time. So we finished this article, and let's take up our next article for the day. The next article which appears in the newspaper reads, Qatar, China sign world's longest gas supply deal. Now this particular article becomes important from the rising, one can say, nearness in the relations of Qatar and China, where in a significant deal, it has signed the supply of gas from Qatar to China. So what is this deal all about, and what is this gas field from which Qatar is transferring the gas to China? We'll have a look at that. Now, Qatar Energy is the firm from Qatar which would be transferring the gas. It will send 4 million tons of liquefied natural gas. This is the natural gas which Qatar extracts from the region, and it would supply to China annually from its North Field East project to China's Petroleum Chemical Corporation. This deal marks the longest gas supply agreement in the history of the LNG industry, which means that all the way from Qatar, the gas supply would be there to China. And why is this happening? Because Asian countries led by China, Japan, South Korea are the main market for Qatar's gas now, because all of these countries were earlier taking their gas supply from Russia, and due to the Russia-Ukraine war that is happening and the sanctions that are being laid on Russia, therefore Qatar is coming out as a new exporter, and therefore for Qatar these countries are the new market. So this is why this deal is significant, and it is therefore the longest gas supply agreement. This deal says that the gas would be supplied from Qatar to China for 27 years from this particular deal. So this is about the deal. And now let's talk about the North Field. This North Field is nothing but the area of sea from where the natural gas is extracted. This is at the center of Qatar's expansion of its liquefied natural gas production by more than 60% to 126 million tons a year by 2027%. So talking about the North Field, it's a very important aspect to talk about Qatar, is because all the development that we see about Qatar, it is also recently hosting the FIFA World Cup. All of this, it has been able to achieve this kind of prosperity is because of this natural gas field, and a huge chunk of the natural gas field belongs to Qatar, and this is known as the North Field. A part of it belongs to Iran as well. So the southern part of it belongs to Iran and the northern part of it belongs to Qatar. And as we can see, the majority part belongs to Qatar only. This is how the Qatar, and this North Field accounts to approximately 10% of the total liquefied natural gas reserves of the world. So as we can see, this is a very significant chunk that Qatar has, and therefore using this, it accounts approximately 10% of the world's known resource, and therefore China is the first country to seal a deal for the North Field eastern portion. The eastern portion of this particular field, with respect to that, China is the first country which has signed a deal with Qatar. So this becomes an important news for us to know. And with this, we finish today's articles and come to the end of today's discussion. We'll meet again tomorrow with the important articles from the newspaper. Thank you.